Mr. Shima, would you care to do the honors as the clerk of the Supreme Court?
Please, Court. Your Honor, the final case for today is number 116773 in the matter of Uche Wakama, respondent, original action and discipline.
May it please the Court, Stan Hazlitt, appearing for the Disciplinary Administrator's Office, ready to proceed.
May it please the Court, Deborah Hughes, Deputy Disciplinary Administrator, present and ready to proceed.
Your Honor, that concludes the docket for today and this week.
Thank you, Mr. Shima. Is Uche Wakama in the courtroom? Mr. Wakama. All right, counsel, you may step forward to your counsel table. I might mention that this case had originally been set for our docket on Wednesday in the morning, and the day before that, May 2nd, we received a document from the respondent indicating that he would like an emergency motion for continuance, or in the alternative, a request for a telephonic hearing, because his daughter had broken her arm on Sunday. And he further alleged in his document that his wife was taking law school exams. He was the only one able to care for his daughter, and he would not be able to make it on the scheduled date and time. We turned down his request for a telephonic hearing because our Supreme Court order requires the respondent to be here in person. But we did grant a concession to him, even though this was not an affidavit that he presented. We took his allegations to be true, and we rescheduled from yesterday until this afternoon at 1:30 to give him time to come up from Texas for this event. About an hour or so ago, we got a fax filing. Did the administrator's office get a copy of this document as well?
Yes, sir, we did.
Just for the record, I wanted to indicate that instead of his being here today, what he sent us was his appearance in the Municipal Court of Sugar Land, Texas, to appear to plead no contest to the offense of illegal parking, and it appears to indicate handicap parking stall. And there was a document attached to that to confirm he was in municipal court at that time. It is the opinion of the court that we gave him adequate notice to attend today, and his priority, at least in my view, was to come here to defend himself and his law license instead of going to municipal court. So with that background in mind, we will proceed. Counsel?
May it please the Court, Stan Hazlitt, appearing for the Disciplinary Administrator's Office. Ms. Hughes and I prosecuted a case, or presented a case to a panel from July 25th through July 29th of 2016, in which the respondent, Mr. Wakama, was the respondent. I'd like to give you a little procedural background of this case, because there was a lot that happened as we finally got up to July 29th and afterwards. The panel report was filed in this case on October 18th of 2016, was 98 pages long. That happens, I guess, when you have a 5-day hearing. The case was docketed with the clerk's office on November 7th of 2016, and the citation was issued by the clerk's office on that same day, November 7th. On November 9th, our office filed a motion requesting that the respondent be temporarily suspended by this court. The panel had urged us to do that. We had made the decision to do that, as even if they hadn't made the recommendation, we were going to do that. On December 6th of 2016, the respondent did file exceptions to the panel report. And on December 15th of 2016, this court issued its order to show cause to the respondent to come and appear before you to explain why he shouldn't be temporarily suspended. That date was January 24th of 2017. On January 17th of 2017, the respondent requested an extension of time to file his brief. We didn't oppose that, and the respondent was given until February 3rd of 2017 to file his brief. Then on January 23rd of 2017, the respondent filed a pleading entitled Notice of Absence for Show Cause Hearing. The respondent notified this court that he would not appear at the show cause hearing. On January 24th, the show cause hearing, our office appeared. He did not. We requested that he be temporarily suspended. And on January 27th, this court temporarily suspended the respondent. That temporary suspension order remains in effect. In fact, he was suspended administratively prior to that time in October of 2016. Then on February 3rd of 2017, the respondent filed a pleading entitled Notice of No Brief Submission and advised the court that in spite of taking exceptions, he was not going to file a brief. And in that document, in that pleading, he said, even though the respondent did not agree with all the findings of the hearing panel, the respondent nonetheless accepts responsibility of his action, inaction, or omission, his staff or attorney's action, inaction, or omission, and does not wish to contest this matter any longer, which I take to mean that he does not contest the findings of fact. But even if he didn't, under Supreme Court Rule 212, if you file exceptions, you say you're going to file a brief, you don't file a brief, then those facts made by the panel are deemed admitted. And in this pleading, or wasn't pleading, but what he filed today at about 12:05, he admits responsibility. I do want to concentrate a little bit on the facts of this case, even though he's not here today, and I'll explain right out of the chute here why I want to do that. All of the misconduct found with respect to his representation of two clients occurred in Texas, and I'm going to explain a little bit about his license status in Texas and here. He's never practiced law in Kansas. He took the bar here and passed the bar here. The disciplinary proceedings in Kansas at the time, going back to July when we had the 5-day hearing, generated a lot of publicity in Texas, and this was discussed and is in the record from the July 5-day hearing. Beginning in July of 2016, Univision in Houston, which is an American Spanish-speaking TV network in Houston, began a series of investigative reports about Mr. Wakama and his law practice. Almost immediately after those investigative reports started appearing on TV, Mr. Wakama sued Univision in the Houston courts. And he also sued Jay-Z, which is another complainant in this disciplinary complaint. I'll talk about him in just a couple of minutes. And Raed Gonzalez, who was Jay-Z's new lawyer. So they were all defendants in this lawsuit. The panel found that within that lawsuit, that the respondent made two false statements. Number one, about the status of his license in Kansas. And number two, he represented that he didn't, in his pleading, he represented that he did not represent Jay-Z, which the panel also found to be false. And I start here because this case has generated a great deal of publicity. I would like to emphasize the facts a little bit because I believe there's an audience watching this here today. I would like for them to see this process working out, for them to understand what we're doing because of all the publicity it generated in the Houston area. The first thing I want to talk about briefly is his law license, or law licenses, and the panel's finding. Respondent was admitted to the Kansas bar in September of 2003. As I stated earlier, he's never practiced law in Kansas. We are the only state, however, in which he actually received a license from that state. The testimony was that, he failed the Texas bar twice, and he came to Kansas and he took the bar in Kansas and passed it. Because he was in good standing in Kansas, he was admitted to the U.S. District Court, the District of Kansas, although he never practiced in that jurisdiction. He was admitted to the U.S. Immigration Courts, specifically the one where he practiced, which is in the Southern District of Texas. And I think the court's aware of this, and it was a problem in this case. Once you're admitted and in good standing in any state, you can practice in any immigration court in this country. We've already had one serious case where a lawyer passed the Kansas bar, Mary Ellen Brooks. She went out and practiced immigration law in California, resulted in numerous client protection claims being made. Her disbarment here, and it all arose out of her representation of immigration clients in the California immigration courts. And one of the two complaints here in this formal complaint was a client that the respondent represented in the immigration courts in Houston, Texas. It causes, and the panel commented on it, a huge problem to be able to investigate and prosecute these types of complaints just because of the distance. And the panel recognized that. I mean, we presented testimony. We were able to set up testimony through Skype, and that made it easier, but we still had interpreters in our courtroom because of the language problems. But I think I'd like to take that up as a cause with the immigration courts to see if there's something that we might be able to do about that. But anyway, he practiced in immigration court. He was also admitted in the U.S. District Court of the Southern District of Texas, also for the U.S. Court of Appeals for the Fifth Circuit in Texas. The respondent is presently suspended from all those courts. He has no place where he can practice at the present time. In Kansas, his license for the time he was licensed in Kansas was suspended 6 different times for administrative reasons, CLE or attorney registration. In 2015, he was suspended. He sent in his checks to be reinstated. The check to the CLE Commission and to attorney registration both bounced. He then made them good. He was reinstated, and in the very next compliance period in 2016, he was suspended because he didn't comply with either one of those. The panel found that his failure to follow the rules of this court with respect to his license adversely reflected on his fitness to practice law. The first of 2 cases that we prosecuted against him involved his representation of an individual by the name of Emo. Mr. Emo was charged with 55 felony counts of Medicare and Medicaid fraud. This was in the Southern District of Texas. He was allowed, and I don't understand exactly how it works, but not only was he allowed to practice in immigration courts in the Southern District of Texas, he was allowed to practice in their criminal courts as well. Mr. Emo, this was no small case. I mean, he had set up a physical therapy place in Houston, and he billed out around $45 million worth of Medicare and Medicaid billings to the government, and actually received payment. It was all a farce. But he actually received payment in the amount of $27 million from the United States government. So he was charged, and the respondent agrees to represent Mr. Emo in this case, even though he had never had a jury trial, even though he had very little criminal experience, and even though he'd only been out of law school for 6 years. In fact, one of the findings made by the panel was that he testified, the respondent testified that he had 1 jury trial, but he couldn't remember anything about it. He couldn't remember if it was a civil case or a criminal case. The panel concluded it was one instance where they felt that he had provided false testimony to the panel, because if you're 6 years out of law school and you've had 1 jury trial, they concluded you're more than likely going to remember that you actually had a jury trial and what it was about. So he agrees to represent Mr. Emo, or find somebody who would be willing to do it. He enters into a written non-refundable contract, which he prepared, for $3 million. The respondent actually collected $2,170,000 of that amount through various documents, and his testimony at the hearing, he said he only collected $1,950,000. Ms. Hughes was able to, when we were able to get bank records from the respondent, Ms. Hughes was able to figure out that he actually received $2,170,000 from the respondent. So there was a $220,000 difference between what he said that he received from Mr. Emo and what he actually received from Mr. Emo. Another thing that the panel found showed that he didn't have really good trust account practices. The respondent actually testified that he earned all the fees and was actually entitled to receive more. The panel found that his fee was unreasonable. In fact, the respondent did not represent Mr. Emo in the underlying criminal case. He hired somebody else to do that. And he paid that person, in spite of the fact that that person's fee was $250,000, he only paid him $200,000 of that $250,000 fee. The panel found that a reasonable fee under the circumstances for this 55-count felony case, Medicare and Medicaid fraud, would have been $250,000. When the respondent was providing his response to this complaint, he gave us an accounting. And it basically said he had received $1,950,000. We now know, and the panel found it was $2,170,000. In the accounting he provided, he said he had expenses of $839,000, which included the $200,000 that he paid to the lawyer who actually tried the case, plus $250,000 that he paid to a lawyer who just basically absconded with the money. But anyway, he lists $839,000 worth of expenses. That would leave him $1,331,000. I hope my math is correct there. He also represented in that accounting that he provided over 6,083 hours during his representation of Mr. Emo. Then he claimed in the accounting that he really came up on the short end of this deal because he was still owed, according to his 6,000 hours at $300 an hour, he was still owed $713,000 that he had not been paid. So the unreasonable fee, the failure to provide an accounting to Mr. Emo, there were 2 letters that Mr. Emo said that he sent to the respondent requesting an accounting. The respondent testified during the hearing that he never received those letters, that he knew that Mr. Emo had made those letters up. The panel found that that was misleading and false testimony that the respondent gave during our hearing. Failure to provide a refund of the unearned retainer. And finally, in connection with this case, the panel found that the respondent violated 3.4F by entering into a written settlement agreement with Mr. Emo in which Mr. Emo agreed not to cooperate with our office, not to testify in the disciplinary proceeding. And part of the requirement was that Mr. Emo send us a letter to that effect, which he did. So we resolved all this. I don't wish to cooperate. I won't cooperate anymore. We got this letter just a couple of days before we were to go down to South Carolina to take Mr. Emo's deposition, who was in a federal correctional facility down there at that time, serving a sentence of 30 years, I believe it was. In return for that, for not cooperating with us, not testifying for us, sending us the letter, he was to receive $425,000. Panel went on further to find that the agreement was designed to circumvent the forfeiture order against Mr. Emo issued by the federal court, because the payments were to be made to Mr. Emo's family. This last conduct in and of itself justifies disbarment. I mean, there's so much more, but that by itself, in our opinion, justifies disbarment. The representation of Jay-Z was an immigration client. And the exhibit showed that his practice was primarily immigration clients. He said that the Emo representation precluded him from representing a lot of immigration clients. Well, we got the immigration docket, and he was representing a lot of immigration clients during the time he was representing Mr. Emo. But Jay-Z had been ordered to leave the country due to the fact that he had 3 DWI convictions in this country. Jay-Z paid a $6,000 fee, which was paid in 2008. Later on, paid an additional $1,500 for a total of $7,500. The respondent assured Jay-Z that he could take care of the problem. He prepared an I-212 form, but there's no evidence that he ever filed it. Again, this began in 2008. Nothing was done in the immigration matter for 6 years. It's typical of these folks. I mean, they give money to a lawyer. It may be all the money they have. It may be all the money that they can borrow. And then they're stuck with that lawyer. 6 years he stayed with this lawyer because he really had no other option. Finally, he does fire him in 2014. Hired new counsel. That's Raed Gonzalez. He's one of the ones who's, along with Jay-Z, who's a defendant in the Univision lawsuit. New counsel was able to get Jay-Z's case reopened. and the removal proceedings were closed down against Jay-Z so he could stay in this country. And it's a good ending to the story because he's now a United States citizen. By the time we had the hearing, all of that was resolved. All of what the respondent did to harm him was resolved. New counsel testified that had the I-212 form been filed, that would have resulted in Jay-Z having to leave the country and not being able to come back into the country for 20 years. So competence, diligence, communication, fees, they said essentially converted $7,500 in fees, failing to provide an accounting and failing to return unearned fees. Just a couple of more things. His trust account, because it wasn't easy, but we received the trust account records, some trust account records from the respondent. To say that there were problems with that trust account would be a tremendous understatement. Basically, we had trust account records from the time that he began to represent Mr. Emo until the time that concluded, which was August 2009 through December of 2011. There were bank statements, but there were no ledgers. There were no records from which you could glean what was going on in this trust account. That's evidenced by the fact that he was $220,000 short in the amount of money that he received from Mr. Emo. $220,000, he couldn't figure that out. Numerous instances of commingling, although he explained that because it was obvious from the records that he placed large amounts of his personal money into his trust account. And he said it was okay because there was no client money in there. So long as there was no client money in there, then that it wasn't commingling. But if you looked at the records, you could see that he would place filing fees. There was one settlement. So there was always some client money in there. So it was always a commingling situation. But even if there had not been that problem, he was still using that trust account for personal purposes. He was paying payroll out of it. He was paying, not to make light of the situation, but he paid for a toilet seat out of it. There were just all those sorts of payments out of his trust account. Numerous overdrafts. Panel found that it was a complete lack of understanding on his part of his responsibilities with respect to the trust account. Panel and our office both recommended disbarment. Really, I think the facts show there's almost unprecedented misconduct in this case. Certainly injury involved to the people involved. I don't feel really sorry for Mr. Emo, except for the fact that a lawyer has a responsibility if they're going to take money to represent the person, no matter how reprehensible. And the respondent certainly didn't do that. In reaching the recommendation, the panel found that the respondent had engaged in bad faith obstruction of the disciplinary process by submitting false information. In his written response to the complaint, when we received his written response, the panel found that there were 7 instances in that written response where he just provided false information. Tried to mislead us. 4 occasions, the panel found that during his testimony, during the disciplinary hearing, that he provided false testimony. He refused to acknowledge any misconduct. The panel cited 4, which I believe are all applicable ABA standards, which stand for the proposition that he should be disbarred. It is our strong recommendation that he be disbarred. I would cite to you the N. Ray Baker case. My license is on the line. I'm going to be here. Illegal parking ticket's not going to keep me from being here. I also want to say, when I read what he filed today at 5 after 12, I saw him talking about acceptance of responsibility, basically a plea for leniency, do anything to me but disbar me. I would ask that you look at pages 89 through 91 of the final hearing report. If he's accepting responsibility, he certainly did accept responsibility during the hearing because he just denied that he had violated, that's within the panel report, he denied that he violated any of the rules of professional conduct. It just wasn't there. There was no acceptance of responsibility. I thought at various times that the respondent might surrender his license during this proceeding. I'm not sure why I thought that, just because I thought the allegations of misconduct were so serious. But I'm glad he didn't. I'm glad whoever's watching this case today understands that our process worked the way it did. And I'm glad that it will result in an opinion, whatever you decide to do, so that the public can see what havoc was wreaked here.
Does that conclude your presentation?
Yes, sir.
Do we have any questions, council? Before you sit down, council, I did want to acknowledge for the record that the document that you received today at 12:05 and that the court received is captioned "Request to be excused from hearing," not that he wanted a continuance as he had requested earlier in the week. So,
Yes, that's what I received at 12:05. Request to be excused from hearing. Request is capitalized. To be excused from is not, and hearing is.
If I see no questions here, no questions. Thank you for your arguments this afternoon.
All right, thank you very much.
Court will take this matter under advisement. That